Hi, in case you haven't heard the news, bail in Maryland has just suffered a setback. The Maryland Supreme Court just bypassed the legislature in changing how defendants are processed. They've directed judges and magistrates to consider bail as a last resort. This was brought forth by Maryland Attorney General Brian Frosh. Their selling point is it's on behalf of the poor, and since the poor can't pay the 10% fee to the bondsman, they claim this change will help the poor. This video will show that that's a lie, and I'll use Brian Frosh's own words in their full context to show this. They're exploiting the poor and hurting the poor to further their agenda of eliminating all bail and expanding pretrial services. Anyhow, last December 9th, Attorney General Brian Frosh was interviewed by Marc Steiner on the Marc Steiner Show to explain it. The Attorney General showcased the dishonesty and phoniness of the entire anti-bail argument. So let's get started. This first clip is at the start of the interview where Frosh states the purpose of the rule change.
What happens is we're keeping people in jail because they're poor. And by that I mean somebody gets charged with, let's say, a minor offense, trespassing, shoplifting, something like that. And oftentimes a judge will set bail for that person in a relatively low amount, $1,000, $2,500, $5,000. It only takes 10% of that to pay a bail bondsman to get you out. But a lot of folks don't have that money. So if you have $1,000 bail and you can't come up with $100, you sit in jail until trial. And that means that people who are innocent, because before they're convicted, everybody is innocent. It means we have innocent people sitting in jail.
Okay, besides stating the intent is for the poor, note his concern that defendants are to be treated as innocent because it's before their trial. This will be dealt with next, but getting back to the issue of the poor, listen to what he says later at about 9 minutes into the interview.
In the rule that the judiciary is considering, the judges, if they make the same determination that they do now that the person is dangerous and shouldn't be let out, instead of saying bail is going to be $500,000 for you, they'll just say, I'm not setting bail. Sit and wait until trial. If they think a person is not a risk, they won't set bail at $2,500, forcing the person to pay $250 to get out and to sit in jail if they don't have $250.
Okay, so no more $500,000 bonds. Shut down all high-risk releases. Those defendants must remain in jail. Bail is denied. What about due process for all, regardless of what the person has? A $50,000 bail fee would not affect the poor. It only undermines the entire principle of bail. And what is the number to deny bail? $100,000 or a $50,000 bond? Then on the other end of the spectrum, in the case of a $2,500 bond, just release the defendant. But he's not talking about the poor. He's talking about everyone. He failed to mention that the Maryland citizens will now absorb all the costs and all the risks for all of the defendants, including the wealthy who would otherwise pay for it themselves. Why should the Maryland taxpayer pay the bail of a wealthy drunk driver? But now, getting back to Frosh's point that defendants are to be considered innocent before trial, listen to his proposal.
For people who are not a threat, and for people who are likely to show up for trial, then either release them on their own recognizance or set non-monetary conditions. Make them take a drug test once a week. Make them report to a parole probation officer every once in a while before trial. Make them wear a GPS device if we're worried about them.
Innocent until proven guilty, huh? In Frosh's words, I think he means make them or make the defendant take a drug test once a week. Report to a probation officer. Wear a GPS device. Just one question. If they're innocent, how can you make do anything? You shouldn't be able to make do anything. He's describing probation, which is a form of punishment after having been tried and found guilty, except Frosh is forcing it on defendants prior to any findings or admission of guilt. It's pretrial services. And something else, regarding Frosh's suggestion of issuing GPS devices are not free, and defendants are forced to pay for them, including the poor. This is a sham, and everyone involved in the criminal justice system, from the defendants who have to go through it, to the lawyers, to the judges, know it. This is simply a power grab for the expansion of pretrial services, which is one of the most corruptive influences on our criminal justice system. Pretrial services removes the principle of innocent until proven guilty and sets up defendants to fail. You can see my pretrial services video for a quick, complete explanation of what pretrial services actually is and how it has corrupted our criminal justice system. Now, moving on to the claim that eliminating bail will save taxpayers money, Frosch states,
those are conditions that save the state money and are more respectful of the rights and problems of the people who are in our justice system.
And later,
our General Assembly could set up that kind of county-based system. They could help the counties with the money if they wanted to. Or they could certainly create incentives for it in one way or another.
The first cut, he claims these non-monetary pretrial services alternatives saves jurisdictions money. But in the second cut, he suggests the General Assembly passed legislation for the state to help the local jurisdictions pay for it. If it saves money, why does it need to be paid for? Again, he's really talking about creating and expanding pretrial services agencies, which cost lots of money. It's an entire government agency to be funded by Maryland taxpayers. Bail costs taxpayers nothing and has far better results. Okay, now moving on to the claim of better failure to appear rates. Here he's talking about jurisdictions which handle bail with pretrial services.
You know, other jurisdictions that handle pretrial justice in fashion save money and have the same offense rates or better or lower offense rates between arrest and trial and better failure to appear rates.
Well, I haven't studied how pretrial arrest rates compare between public and private bail, so while I don't believe him, I won't comment on that. However, I do know how failure to appear rates compare between the two, and private bail has significantly lower failure to appear rates than any public bail mechanism. This has been researched and verified over and over again, and it's never close. For example, a Bureau of Justice report published in 2007 found that private bail had an 18% failure to appear rate, while those released on unsecured bonds had a 30% failure to appear rate. Also, there have been numerous jurisdictions which went to the public evidence-based, risk-based assessments and reverted back to commercial bail because of the skyrocketing failure to appear rates. And there are games being played in jurisdictions which obfuscate failure to appear rates. As Chief Judge of the 5th Judicial Circuit, Craig DeArmond, pointed out in his Bail Reform, Is There Another Side to the Argument article, many failure to appear rates for unsecured bonds go unnoticed because of the increase in trials in absentia, where the failure to appears are instead categorized as meaningless convictions. All right, now let's look at these risk assessment tools Frosch speaks of.
We can dramatically improve outcomes if we use these evidence-based risk assessment tools. And in those situations, I mean, and it's been shown over and over again, in those situations you can improve the failure to appear rates and you can improve the offense rate when people are out on bail. Judges are going to make mistakes, but they can do it better if we're basing our decisions on science.
Oh, geez. Frosch's overuse of buzzwords is both nauseating and laughable. I'm talking about risk-based and evidence-based tools, and the best of them all, science. Ooh, science. Basically, these buzzwords are what government workers use to determine the flight and offense risk of a defendant. According to the Pretrial Institute's State of the Science of Pretrial Risk Assessment, there are 6 factors used to evaluate defendants. They are prior failure to appears. That's right, if a defendant has a record of not showing up to court, they're high risk. No. Does a defendant have a record? Are any of the present charges a felony? Is the defendant employed? Is the defendant a drug user, and to what extent? Does the defendant have any other pending charges? Yes, gathering this information to make an assessment is what Frosch is calling science. Responsible bondsmen always get this information prior to writing a bond. We refer to it as screening. It's just common sense stuff, not science. And it's really a joke to bondsmen and others who work in the criminal justice system when officials like Attorney General Frost speaks of these things as if they're some complex scientific tool requiring some kind of advanced training. I refer to this as Barney Fife bureaucracy. Hello, Maryland Attorney General Barney Fife. And finally, the rule of law. When Marc Steiner asked Attorney General Frost if this ruling would render the General Assembly moot or unimportant, he responds,
No. In fact, there is much that the General Assembly could do that would be very important and that would continue to improve the pretrial justice system in Maryland. So, for example, they could direct each local jurisdiction to create a pretrial system that uses evidence-based, science-based analyses of whether the person is likely to offend or not. And these kind of risk assessment tools are in effect in other jurisdictions and work extremely well. And so, our General Assembly could set up that kind of county-based system, and the state could help the counties with the money if they wanted to. Or they could certainly create incentives for it in one way or another, and that would be a great way of making progress.
That translates to no, the General Assembly will remain relevant on this issue as long as they pass laws to further the anti-bail agenda. They should also mandate that jurisdictions create and fund pretrial service agencies. He also admits that it couldn't get done in the General Assembly. He apparently doesn't understand or care that that's the way democracies and republics are supposed to function. What has been done is 7 people decided a critical issue against the will of the people. This is the form of tyranny, and it's wrong. So, in summary, the anti-bail agenda is bad for the defendants, communities, and our criminal justice system. If it is really as superior as they claim, they would be able to tell the truth about it rather than spout inconsistencies and falsehoods as Attorney General Frost did throughout the interview. Their agenda exploits the poor, and it is the poor who will suffer the most. This will mean more defendants will be ensnared in pretrial services, which unjustly keeps defendants in the system. This is bad policy, and it's immoral. I'm Dan Bardo, a Richmond, Virginia bail bondsman. Thanks for watching.